Procedure. Adversarial versus inquisitorial systems of justice. Adversarial and inquisitorial systems of justice represent two different means of conducting trials. Adversarial. The adversarial system is based on the opposing sides, acting as adversaries who compete to convince the judge and jury that their version of the facts is the most convincing. The lawyers are given free choice in terms of which issues are presented, what evidence to adduce in support of their submissions, and what witnesses to call. The judge presides over the trial and rules on disputed issues of procedure and evidence, asking questions of the witness only to clarify evidence, and concludes the trial by summing up the facts for the jury and advising them of the relevant law. It is not open to the judge in an adversarial system to inquire beyond the facts and evidence that are presented by the opposing lawyers. His role is largely passive. He is an impartial referee who advises the jury on matters of law. This differs dramatically to the role of the judge in an inquisitorial system, which is based, as the name suggests, on an inquiry into the case. Thus, the judge is not limited to hearing the submissions of the parties but can direct the lawyers to address specific points or to call particular witnesses. The title of the presiding judge is juge d'instruction, which translates as investigating magistrate, in the French criminal justice system, gives an indication of the role of the judge in directing proceedings. Unlike the adversarial system, the role of the inquisitorial system is not to determine guilt or innocence of one particular person but to find the truth. As such, the judge, as investigating magistrate, conducts an inquiry that involves the questioning of witnesses and suspects, the issue of search warrants, and an examination of the evidence with the aim of discovering both incriminating and exculpatory evidence. The prosecution and defense lawyers will keep a close eye on the judge's investigation and can request that he considers specific evidence or takes a particular course of action, but the ultimate responsibility for the line of inquiry remains that of the judge. If, at the conclusion of the investigation, the judge decides that there is a case against a particular suspect, the matter will proceed to trial, which will take an adversarial format. An inquisitorial system involves a preliminary investigation conducted by an investigating magistrate as a means of seeking the truth. It is accepted that the adversarial system does not do this. A trial does not involve the pursuit of truth by any means. The judge's role in that system is to hold the balance between the contending parties without himself taking part in their disputations. It is not an inquisitorial role in which he seeks himself to remedy the deficiencies of the case on either side. R. V. Whithorn, 1983. 152 CLR 657 per Dawson J. at 682. The inquisitorial system appears to be more adept at identifying and investigating the relevant facts and ensuring that this is all taken into account when deciding to proceed with a trial. As such, it seems to be a more cost-effective method of conducting a criminal trial. The central question, however, is whether it dispenses justice. An investigating magistrate may reach an erroneous conclusion that leads to the wrong individual being tried in circumstances where his presumption of innocence is eroded. An adversarial system protects against wrongful convictions by ensuring that the process is slanted in favor of the defendant in the belief that it is better for 10 guilty men to walk free than for one innocent man to be imprisoned. Civil Procedure Code 1908. Instituting a suit. 1. Plaint presented in a court doc containing claim of plaintiff plus relief. 2. Procuring presence of the defendant, Order V of CPC. Summons issued, Section 27 of CPC. 3. Defendant's written statement, within 30 days of receipt of summons. 4. Failure to make a written statement by D. Judgment against D. Order 8. Rule 10 CPC. 2. Pre-trial proceedings and ADR. 2. Pre-trial proceedings and ADR. Section 89A. Courts under an obligation to encourage parties to reach resolution at pre-trial stage. Order X. Rule 1A of CPC. 1A. Direction of the court to opt for any one mode of alternative dispute resolution. After recording the admissions and denials, the court shall direct the parties to the suit to opt either mode of the settlement outside the court as specified in subsection 1 of Section 89. On the option of the parties, the court shall fix the date of appearance before such forum or authority as may be opted by the parties. Recording of evidence. Order 14, Rule 1 CPC. Framing of issues Qanon-e-Shahadat. Order 1984. Points on which evidence is led plus on whom lies burden of proof. Order 18 CPC. Mode of taking and recording evidence. Judgment and decree. Section 33 CPC. Court pronounce its judgment followed by a decree. Section 48 CPC. Execution of decree take place within 6 years from date of decree pronouncement. Criminal procedure. 1. Investigation. 2. Prosecution. 3. Trial. Investigation. Section 4. 1. Defines investigation as proceedings for collection of evidence by police officer, or any other person authorized by the magistrate. Cognizable offense. A cognizable offense is one in which the police may arrest a person without warrant. They are authorized to start investigation into a cognizable case on their own and do not require any orders from the court to do so. Non-cognizable offense. A non-cognizable offense is an offense in which a police officer has no authority to arrest without warrant. The police cannot investigate such an offense without the court's permission. FIR. First Information Report. FIR is a written document prepared by the police when they receive information about the commission of a cognizable offense. It is a report of information that reaches the police first in point of time, and that is why it is called the First Information Report. FIR Section 154 Crossing PC. The object of Section 154 of Crossing PC is twofold: to set the law, criminal, in motion, and collection of evidence. Who can lodge and FIR? Anyone who knows about the commission of a cognizable offense can file and FIR. It is not necessary that only the victim of the crime should file and FIR. Also, the investigation process has 3 steps, broadly speaking. 1. On complaint of a cognizable offense, a PO can investigate. 2. On inaction of police, complaint can be filed before a magistrate. 3. In non-cognizable police, not obliged to investigate, process can be started by filing criminal complaint before a competent court. Evidentiary value of FIR. FIR is not a sacrosanct or substantive piece of evidence and is only information to put machinery of law into motion. In case of false FIR, Section 182 of PPC deals with punishment. Bail. Section 496, 497, 498, 498 ACRPC. Grant of bail in 2 cases: I. Grant of bail in bailable offences U. Sec. 496, E. Grant of bail in non-bailable offences U. Sec. 497. Grant of bail in non-bailable offences U. SEC 497. Non-bailable offences may be categorized into the following kinds. A. Offenses not punishable with death, imprisonment for life or imprisonment for 10 years. B. Offenses punishable with death, imprisonment for life or imprisonment for 10 years. General rule. As a general rule, bail shall not be granted in cases punishable with death, imprisonment for life or for 10 years. Cancellation of bail U.S.C. 497, 5. On the following grounds bail may be cancelled: A. If the accused commits the same offense again. B. If the accused is trying to tamper with the investigation. C. If the accused is trying to tamper with the prosecution's evidence. D. If the accused does not appear in court at hearing. Double jeopardy. Section 403 crossing PC is based on this ancient maxim: nemo det spis uexariproeadem. No person should be disturbed for the same cause. Relevant provisions. Section 403 crossing PC Article 13. A. Constitution of Pakistan Section 26 General Clauses Act Section 11 of CPC Rule of Jeopardy under Section 403. Section 403 crossing PC contemplates a situation where a person has once been tried by a court of competent jurisdiction and acquitted or convicted by such, cannot be tried again for the same offense nor for any other offense based on similar facts. Prosecution. Both sides present their case. Lawyers as officers of the court trial. One party, state. Other party, accused. Charge framed evidence, recorded witnesses. Examined arguments, undertaken judgment. Entered, conviction and sentence or acquittal. Constitutional requirement. Trial is fair plus due process. Observed. Trial in open court. Duty of judge to prevent abuse of process through delay, adjournments, evidence. Quanon-e-Shahadat Order. 1984. Article 2 defines court as all judges and magistrates and all persons except arbitrators. Article 165. Shall have effect notwithstanding anything